Hello, my name is Richard Santos. I was just going to go over a brief presentation titled Injury in Fact, and we'll just get right into it. So the first slide will go over the requirements of injury in fact. Um, it's necessary for a party to demonstrate a injury in fact to their own legal interest in order to obtain something called standing, which standing and injury in fact can essentially be interchangeable. Stated differently, the party that actually suffered any harm. And it's also worth noting in constitutional law, the term usually refers to a person's freedom and rights that are guaranteed by law. The party does not have standing and is not the appropriate party to be in court if they are unable to demonstrate injury. A party's standing only indicates that it has sufficiently alleged a legal interest and injury to be allowed to join in the lawsuit. It does not guarantee that the party will prevail. And we'll go ahead and continue on here. Not even injury qualifies as a injury in fact, not even a potential injury. Injuries in fact have to be actual and a type of accepted law. This is typically understood that it is insufficient for there to be a chance of harm occurring or for a citizen to be involved in the case. For a party to have standing, they must truly sustain the harm. Moving on to the demonstrations of injury, federal courts do have jurisdiction over cases and controversies arising under federal law, according to Article 3 of the U.S. Constitution. According to how the U.S. Supreme Court has interpreted these phrases, a plaintiff needs to prove, standing to file a lawsuit in federal court, which means the complaint needs to be founded on a specific and concrete claim of real or impending harm. Historically, lawsuits filed by plaintiffs to uphold their statutory private rights have nearly always satisfied requirements such as this. Congress has the authority to pass legislation that establishes new legal rights and gives people the ability to file a lawsuit when someone else violates those rights. The Supreme Court's recent rulings in a case with Spokio Incorporated versus Robbins and TransUnion versus Ramirez have actually been in place to question Congress's authority to correctly establish rights that are challenged in the federal court. Uh, at that time, the court had declared a new rule that deviates from decades of precedent regarding Article 3, which is the proof of concrete harm as opposed to merely legal injury, is a universal prerequisite of Article 3. It is still unclear exactly what it is meant by concrete harm. In terms of obligations of private companies and government agencies for data breaches, generally speaking, a business must achieve certain objectives in the event of a data breach. Of course, maintain control, but keeping things under control to stop the data breach from getting worse. Informing individuals who are impacted on the issue. In addition, it demonstrates intent to safeguard or restore sensitive data and conforms with regulatory bodies that are requiring reporting if any cyber incidents. And of course, to stop similar occurrences in the future and get the company back up and running. This, of course, resolves in fixing the breach and addressing any associated risks. Uh, because I do reside in Texas, according to the Texas law, I just wanted to input this, that companies and organizations who suffer a data breach of system security that impacts 250 or more Texans or Texas citizens are required to notify the Office of the Texas Attorney General as soon as it is reasonably possible, but no later than 30 days following the breach discovery. And here are my references for the slideshow, and that will cover everything in this presentation. Thank you.